Dear students, we are going to learn a new module, implied warranties. So implied conditions are there in a sale of contract that we have already explained and we have learned that. And then now we have implied warranties also. These are two basic things in the Sale of Contract Act. Now let us see what are implied warranties. What is the meaning of implied warranty? Implied warranty is an assurance that a product is fit for its intended purpose. See, if I am buying a wheelchair, I don't have to tell the seller that I want a wheelchair for this purpose. So it's understood. If I am buying a feeding bottle, trolley or anything, if I am buying a laptop, smartphone, one gas stove, anything, it's fit for the intended purpose. Second is, it meets the buyer's expectations. The gas stove which I'll buy, I want to use it for cooking. So it will suit my requirements and it will fulfill my expectations. So this is, you have to remember that other than the implied conditions, implied warranties can be written or oral. Because it's not, sometimes when they negotiate with the seller, he will mention that as the implied warranties he will mention. So that is either written or oral, because mostly it is oral conditions only. Now what is the importance of implied warranty? The two key types of implied warranties are merchantability and fitness. So merchantability says that the product will meet reasonable expectations of the buyer, while fitness means the product meets buyer's intended use. So these two conditions I have already explained. The buyer's reasonable expectations the product should fulfill, and it will suit the intended purpose. If you are buying a smartphone, we know that why we are buying a smartphone. So the intended purpose it has to serve. And then my reasonable expectations. I will do my research and I will select a smartphone, which one I want to buy. So that I will tell the seller, so that will fulfill when I buy that product. So this is the importance of implied warranty. Now implied warranty, we have to remember there are 3 points. So the 3 points first I will list, then I will explain. Warranty as to quiet possession. Second is warranty as to freedom from encumbrances. Third, warranty to disclose the dangerous nature of goods to the ignorant buyer. Now let us see in detail these points. So first point is warranty as to quiet possession. So this warranty is given by section 14 subsection B of the Sale of Goods Act 1930. Now if you see the definition, the buyer shall have and enjoy quiet possession of the goods. Once you buy something from a seller, you are getting, when the ownership is transferred to you, you are getting the absolute right. Nobody can take it from you. So if it's a stolen item, there will be a different thing. If you have threatened somebody and took that item and seller is selling that, it's a different item. Actual owner will come and later, it will disturb that, or it will disturb you. He will come and disturb you. It may go to legal proceedings. All these cases will be there. So quiet possession we have to get. That meaning seller, when he is selling the goods, he should be the actual owner. So when he will transfer the ownership to the buyer can enjoy the ownership. Nobody will take it from him. So that is the importance of warranty as to quiet possession. This is the first implied condition on the part of the buyer. So buyer is looking for the quiet possession of the item purchased. So there is an important case in this, Mason versus Birmingham. See, Mason bought a second-hand typewriter. So here he bought that, he used it for some time, and then he had spent some amount for repairs also. Usually when it's second hand, we have to spend some amount for the repairs. Later, somebody found that it is a stolen typewriter. So the actual owner came and told him to return the item. So he filed a case against the seller, Birmingham, and then it was decided in the court that Mason is entitled to recover from the seller damages for breach of implied warranty. The price he paid, the amount he spent for repairs, everything he was able to recover from the seller. So this is the importance of warranty as to quiet possession, the actual ownership. Nobody can sell an item which is stolen or which is belongs to somebody else. Use, fraud, misrepresentation, something to get that, and you are trying to sell that. It's not possible. Second is warranty as to freedom from encumbrances. See, what is the meaning of encumbrance? This term we use in banking quite often. See, when I am taking a housing loan, I will pledge my documents, the property documents with the bank till the housing loan is cleared. That meaning I cannot sell that property till the housing loan is cleared. It's encumbrance. It has got some lien on the bank, has got some lien on the property. So the title deeds of the property pledged with the bank. It has got some lien with the bank. Now when it will be cleared? When I repay my housing loan fully. So the banker will give me the property deeds. So second implied warranty is freedom from all encumbrances. When you are giving the ownership, nobody has any lien on the property deeds or the item which you are selling. So that is the second implied warranty. The third is warranty to disclose the dangerous nature of goods to the ignorant buyer. See, this is an important condition, and whenever we are buying something, you can see the dangerous nature. See, if you are buying pesticides for the plant, or you are buying crackers, you are buying toys, all the instructions will be there in the package itself. They will mention that. Especially the seller will tell also, it should not reach the hands of children. You should keep it away from children. All these conditions will be there. So breach of warranty is for not disclosing the nature of goods sold. See, now Diwali season is coming. Crackers, it can be dangerous. So when they are selling that, they will tell that this is the dangerous thing. It should not, the children should not play with that. It should be, see, anything like that. They will tell that the adult supervision should be there. Even when we watch the TV channels also, the parental control should be there. So buyer can claim compensation for the injury caused to him. So if something happens if the seller is not disclosing the dangerous nature, the buyer can claim compensation for the injury caused to him. There is a case in this, Clark versus Army and Naval Cooperative Society Limited. Mr. Clark bought some antiseptic powder from the army canteen. So this happened in 1903. We have to remember in 1923 we are taking this case because that shows the importance. Still now, because of this case decision, we are getting the disclosed by the seller the dangerous nature of the items they are selling. So it's very important, this importance of this case. So this clerk was not aware of that antiseptic powder, what will be the dangerous thing. And the army official, the canteen officials, they have not disclosed it to the buyer. So here what happened is, Mr. Clark's wife opened that powder. It was in a tin. When she opened that, it fell on her eyes and eyes got damaged. Now what will be the consequences? So the consequence will be the clerk went to the court and he got the compensation because his wife got damage to the eyes. That wife's eyes got damaged when she opened the lid the tin without much care. See, it is a duty of the army canteen officials to disclose the dangerous nature. It should not fall on the eyes. You have to be careful when you are opening that. So that was not disclosed. So this case decision, which has happened in 1903, it has got still its relevance. Now one more thing I want to tell you, that though we have implied conditions and implied warranties, the doctrine of caveat emptor will apply. That meaning, this you have to remember, let the buyer beware. You cannot take everything to the court. Everything, if you want to buy anything, you have to do your own research. Now we have all the forums available, website, anywhere, Google you can search, you can ask your friends, relatives who bought similar product. You have to do your own research when you are buying a product. So there are certain exceptions to this rule. The buyer will get certain rights from the court if this violation is there. There are 2 points with that. One is where the seller makes a representation and the buyer relies on it. Seller is giving some claim which is not relevant or which is not correct. So in that case, buyer will get the right from he can establish his right from the court, and the seller will be forced to pay the compensation. Second is consent by fraud. See, sometimes this will happen in land transactions. See, sometimes that they will make duplicate document. They will make false documents and they will sell it to buyers. Usually NRIs and all will get cheated like that. Then if the consent for the sale is obtained by fraud, then also the buyer can get the right established from the court. Seller will be asked to compensate the buyer. So though the doctrine of caveat emptor will apply in general, there are 2 exceptions. One is when the seller is making a false representation, then the seller is obtaining the consent to sell that item by fraud, misrepresentation or anything. So this is what I want to explain in this module. Happy learning. Thank you.